Good evening. I'm delighted to welcome you to the 6th Jonathan Hirst QC Commercial Law Lecture. Our speaker tonight hardly needs any introduction from me. Andrew Popplewell, Lord Justice Popplewell, was called to the bar in 1981 and was a member of Brick Court for the next 30 years, enjoying a stellar commercial practice, both as a junior and as a sook, which rank he joined in 1997. In 2011, he became a judge of the Commercial Court and was promoted to the Court of Appeal in 2019. The invention of the Mareva some 50 years ago in 1975 coincided with when Jonathan, who's sorely missed by all of us, was called to the bar. One of the things that kept Jonathan, Andrew, and the rest of the junior commercial bar particularly busy in the 1980s was running over to court, often before Jonathan's father David, then a judge of the Commercial Court, seeking to obtain or set aside Marevas, which were an extremely powerful, evolving new tool in the armory of civil litigation. It's therefore fair to say that Jonathan and Andrew grew up with the Mareva. Accordingly, it's particularly fitting that Andrew has chosen as the topic for tonight's lecture, the Mareva at 50, a midlife crisis.
Well, as you've heard, 1975 was a very good year for the common law. It was the 17th of July as the date when Jonathan Hirst was called to the bar. And I am very pleased and privileged to have been asked to speak on this occasion, which is dedicated to the memory of such an irrepressibly joyous man, very powerful advocate, great exponent of the common law, and a staunch defender of the traditions of the bar, and indeed a dear friend. And it's very good to see his wife Fiona here, sister Rachel, and son Charles, I think, is on his way. 1975, of course, also the year in which the Mareva injunction was born. And Jonathan was involved in many Mareva-related cases. In one of them, Lord Justice Carr referred to his submissions as lucid and forceful and said he found them most helpful and then rejected them. I shall refer to it as the Mareva injunction, not as it has become following the Wolf reforms, a freezing order. That's not because I'm an old dog who has trouble learning new tricks, although I am that. It's because freezing orders also encompass proprietary injunctions, which are simply a form of interim injunction to which American cyanamide principles apply. And if I referred simply to freezing orders, then what I had to say would risk confusion. I could use non-proprietary freezing orders, but even that would be mildly inaccurate due to some pensions regulations, and it's certainly not as catchy as the Mareva. It's not the only respect in which the well-meaning Wolf reforms have left us with some infelicities of language. The without notice application on notice is a bugbear of mine. I have unashamedly taken the first half of this title from a seminar which was organised in the Business and Property Courts on the 25th of June of this year, which was 50 years almost to the day after the Court of Appeal decision from which the Mareva takes its name. It was in fact born under the midwifery of Lord Denning, the Master of the Rolls, about a month before that, in a case called NYK and Karagiorgos, but it took its name from the second case, also presided over by Lord Denning. The Mareva is a remarkable creation of the common law. It plays a significant role in civil litigation, and I'm inclined to think in making England and Wales an attractive forum, with the consequent economic benefit for the country which that entails. In 1980, when it was still in short trousers, Lord Denning, by this time in his 80s, but not yet retired, described the order as the greatest piece of judicial law reform in my time. I think it's fair to say that Lord Denning's star has waned a little over the years, but of this innovative judicial lawmaking he could indeed be rightly proud. In 1982, Lord Justice Donaldson, who at that time was due to succeed Lord Denning as Master of the Rolls within a few months, famously described the Mareva, then barely of primary school age, as one of the law's 2 nuclear weapons. It was perhaps not the most apposite of metaphors, given that some 3 years earlier, Mr. Justice Mustle, as he then was, had observed that applications were running at the rate of about 20 per month and were almost always granted. I had myself instinctively thought that the number of Marevas being sought and granted had been continually growing over the years, but that may not be so. There are no statistics currently available, but 20 per month is almost 5 per week. And Mr. Justice Mustle's figures may well have been for the commercial court alone. What is undoubtedly true is that the jurisdiction has developed from what were in the early days relatively simple disputes, almost all in shipping cases, and often involving assets which were simply bank accounts, to one in which now there are complex disputes in many fields of law, orders aimed at a wide variety of assets of ever-extending jurisdictional scope. And I think there could be no doubt that Mareva injunctions have become far more extensive and far more intrusive than was anticipated by those which were attendant at the birth. The recent seminar I found to be striking for the views which it revealed. It was very well attended. There was a large audience of judges, barristers, solicitors and other practitioners with fulsome experience of Marevas being granted and their operation in practice. And it was regularly polled, the audience were regularly polled by a show of hands throughout the seminar. And the distinct mood, and very clear mood, of the audience was that Marevas were being granted too readily and that they were operating often unfairly on defendants. And I'd like to explore this evening some aspects of how and in what ways that may be so, and consider some ideas about what might be done about it if something needs to be done. It's not my purpose to advocate any particular reforms, but rather to highlight some areas which might merit consideration. Now, obviously, it's much too large a topic for a single lecture. In a jurisdiction of this nature, there is always room for incremental development by tinkering with particular aspects at the fringes or making drafting changes to the wording of orders in particular cases. But what I wanted to explore this evening is whether it's worth reassessing some of the fundamentals which have become entrenched. So I'm going to confine myself to 3 central aspects of the exercise of the jurisdiction: the merits test, risk of dissipation, and disclosure of assets. Now, I recognize, of course, that the more readily available the remedy, the more attractive that might make England and Wales seem as a forum to claimants. And in the development of our commercial law and practice, it is legitimate to take account of its impact on the economy. We are, after all, in a competitive marketplace. But jurisdiction clauses are bilateral affairs, agreed at a time when parties do not know whether they will be claimant or defendant in any dispute. And if a particular jurisdiction has a procedure which is operating oppressively or unfair to defendants, then that may apply a disincentive to selecting that forum, whether through directly through a jurisdiction clause or even indirectly through an arbitration clause. And as Lord Justice Lawton said in the early days, and he was not known as a softie. Even if a plaintiff has good reason for thinking a defendant intends to dispose of assets so as to deprive him of his anticipated judgment, the court must always remember that rogues have to live, and that all orders, particularly interlocutory ones, should as far as possible do justice to all parties. So first, the merits test. After some initial uncertainty, the merits test was settled in the Niedersachsen, in a judgment of Mr. Justice Mustel, endorsed by the Court of Appeal, as being good arguable case, meaning a case which is more than barely capable of serious argument, and yet not necessarily one which the judge believes to have better than 50% chance of success. And that was the test regularly applied in the commercial court, at least for decades. But it was thrown into doubt by the fact that it had its origins in a test of good arguable case for jurisdiction purposes. And in that context, the expression had been taking on a different complexion in successive cases, which ultimately meant that it was treated as meaning the better of the arguments. And there was developed jurisdiction in that area, in Brownlee, for example, as to how to address disputed evidence in that context. And that was a different and a higher threshold than what the Niedersachsen had determined to be the merits test for a Mareva, notwithstanding that the same expression, good arguable case, was used for both. And the Niedersachsen test for Marevas was thrown into some doubt by the Court of Appeal decision in 2020 in Lakatamia and Morimoto, in which Lord Justice Haddon Cave appeared to equate the Mareva test with the jurisdiction test. It has to be said by way of a throwaway line, and at the same time describing the test as not very onerous. In the Court of Appeal decision in Dos Santos and Unitel, a court of which I was a member, the position was re-examined, and the court confirmed that the merits test for Marevas remained the Niedersachsen test, not the test of good arguable case for jurisdiction purposes. And that aspect of the decision was not, I think, received as one which was particularly controversial by practitioners. What has been received with greater criticism is what I said in a concurring judgment, with which the recently retired Chancellor, Sir Julian Flow, and Lady Justice Falk agreed, which was that the time has come, in my view, to recognise that the gateway, I put emphasis on that, the gateway merits test for a freezing order is and should be the same as that for interim injunctions generally, namely whether there is a serious issue to be tried. That is so both as a matter of principle and because it's no different in substance from the test applicable to freezing orders of good arguable case in the sense defined in the Niedersachsen. And the test for interim injunctions generally, which has been equated with the test for summary judgment, namely whether there's a real prospect of success, is a triable issue, is something which is more than merely arguable and which carries some degree of conviction. And what we said in the Dos Santos case was that that test, more than merely arguable, which carries some degree of conviction, is really no different than Niedersachsen, more than barely capable of serious argument. In other words, the Niedersachsen test is in substance the same. Now, views differ on that, and I don't want to be detained for too long on whether the two tests are the same. What I'm more concerned with for present purposes is whether the test should be higher for Marevas. And in Dos Santos, the court advanced a number of arguments why we suggested it shouldn't be higher, of which I want to mention two. The first rests on the nature of the right being protected by a Mareva injunction. Following the Siskina, it was long thought that a Mareva could only be granted in support of another existing substantive right. And it was that other existing substantive right which the injunction was protecting. However, the Mareva, it has now been explained, has its justification firmly rooted in the protection of prospective rights and interests in what is termed the enforcement principle, as Lord Leggatt explained in Broad Idea International and Convoy Collateral. And although there are some important differences between Marevas and other forms of interim injunction, what we said in Dos Santos was that the nature of the interest being protected in each case is not such as to justify a difference in the merits gateway test. For interim injunctions, the apparent right being protected is an existing substantive legal right, which has a sufficient prospect of being established at trial, resulting in a judgment. For freezing orders, it's a legally protected interest in a judgment being enforceable, but again, on the assumption that there is or will be a substantive legal right, which has a sufficient prospect of being established at trial, resulting in a judgment. And the nature of the interest being protected in each case suggests that the same probability of establishing the substantive right at trial should stand as the merits threshold for both. Secondly, the court said that there's no logic in using a heightened merits test as a threshold requirement to protect against the invasive nature of relief. If a case appears sufficiently meritorious to warrant going to trial, and therefore has a sufficient prospect of a judgment requiring enforcement, the principles which govern whether enforcement should be supported by protective relief ought at least to start from the position that a claim which has a real prospect of succeeding may be just as deserving of protection as a claim with a higher probability of succeeding. If a heightened merits test is to be used as a mechanism for restricting the invasive nature of the relief, that should not be as a threshold requirement, but can be considered at the third stage of the test, namely whether it is just and convenient to make the order. It is by reference to the just and convenient criterion that the apparent strength of the claim may fall again for consideration, just as it sometimes does for interim injunctions, for example, where they may be finally determinative. Now, it may be worth emphasizing that in saying that, we weren't saying anything new. In the Niedersachsen itself, both Mr. Justice Mustel at first instance and Lord Justice Carr in the Court of Appeal said exactly the same thing, that the merits come to be considered at the third stage again. Now, some have argued that that approach is difficult because there is no clear guidance or delineation of how that is to be applied at the third stage of the test. But that is perhaps because the third limb rarely receives any attention at all in the grant of Mareva injunctions. Once a good arguable case and real risk of dissipation are established, the order is usually made as a matter of course without any independent consideration of the third limb. And that, I'm inclined to think, may be unfortunate, especially considering that the whole basis for the jurisdiction in Section 37 of the Senior Courts Act is whether it is just and convenient to make the order. What the Mareva jurisdiction envisaged in its original conception was that the merits should be used not only as a threshold condition, but as part of the wider exercise of discretion. And that approach seems to have disappeared entirely. Now, there have been counter-arguments advanced. Mr. Justice Foxton, as he still is for a while, said in a talk last year that there was a principled basis for a higher merits test, or at least might be, and that it would consist in, and I quote, what is unique about search and freezing orders is that the legal right relied upon to obtain the injunction is not a right pre-existing the commencement of legal or arbitral proceedings and arising under general principles of private law, but a right arising from the commitment to commence legal or arbitral proceedings in pursuit of an award of monetary relief, which subsists only for so long as those proceedings are in contemplation or underway or have succeeded. Close quotes. Well, that may be so, but I wonder how much it matters in practice for the theme which I'm discussing. If the Niedersachsen test imposed a higher merits threshold than serious issue to be tried, it is not by much. And my own experience, at least, has been that it would rarely have made a difference to the outcome. To borrow from Geoffrey Berriman, commenting on the Canadian jurisprudence, to the cynic, the difference may be nothing more than the level to which counsel can shout and remonstrate on the evils of the defendant. If there is a cogent argument for restricting the grant of Marevas through a more onerous merits test, and there may be, then it may well have to be dialed up considerably higher than the Niedersachsen test. And I think it may be worth remembering in this context what Lord Mustill said in Mercedes-Benz and Leduc in 1996. He said, "The remedy is now 20 years old, and the problems of which there is no lack are of a practical kind. How to frame an order which on the one hand protects the claimant against the manipulations of a defendant who may prove to be unscrupulous, without strangling the working capital of a defendant at the instance of a claimant who may prove to be unscrupulous. How to form the necessary judgment at a time when every fact is hotly controverted. How to choose ancillary orders which are effective without being oppressive. These problems did not arise in the early days of the injunction, when the remedy was given only in the clearest of cases, but they have been increasing ever since." If one looks at what happens in other jurisdictions in this respect, some require a higher merits test. Australia has a similar threshold to ours. That's for those of you who are planning to set their alarms for early tomorrow morning. It's a good arguable case in Australia, but that has been described there as a very low threshold. And on the whole, New Zealand and Singapore also follow our jurisprudence. But in Canada, for example, that's the great Beverly McLaughlin, in case you don't know, the former Chief Justice. The federal court has adopted a higher test. They've adopted a test of strong prima facie case, which they have said is a higher threshold than good arguable case. And so have most of the provinces, although not all, in Canada. New York has a much more restrictive approach. That's the even greater Benjamin Cardozo. Orders in New York are only available under a rather more limited jurisdiction, as you probably know, afforded by Article 62 of the Civil Practice Laws and Rules. But within that jurisdiction, what is required is that the claim must be shown to be more likely than not to proceed, a more than 50% merits test. It's a little bit more difficult to draw direct comparisons with civil law jurisdictions. In France, for example, saisie conservatoire is not a direct equivalent because it has in rem effect as providing security for the claim. But for that relief, what is required is, in translation, a claim which appears well-founded in principle, which sounds like one which, on the available evidence, can be seen to be more likely than not to proceed. That is what, in our language, is meant by a prima facie case, although that expression is sometimes understood by people to mean something less than that. Let me move on to real risk of dissipation. That is the conventional, but perhaps inadequate phrase used for the second limb of the test. It refers to the defendant alienating or dealing with assets in a way which renders them unavailable or less readily available to discharge a judgment, and of course includes concealment with that effect. In the early days, there was a suggestion that it was necessary to show that there was a risk of action by the defendant which was intended to have that effect, what has been termed nefarious intent. Anyone know who that is? That's Mr. Ablyazov, exactly, who has so selflessly contributed so much to the contribution of our law in this area. However, nefarious intent is not the test that was settled on, and in the Niedersachsen, in the fairly early days, the test was settled as whether the court concludes on the whole of the evidence that the refusal of a Mareva injunction would involve a real risk that a judgment or award in favour of the plaintiffs would remain unsatisfied. The test is one of effect, not intention. Real risk that will be the effect of something that will happen. Nevertheless, one aspect of the risk of dissipation which may be receiving less attention in practice than it might is that dissipation must nevertheless be unjustified. That is to say, it must be improper in the sense that it's contrary to the legitimate objective of a Mareva injunction. And the purpose of a Mareva, the legitimate objective of a Mareva, is not, as we know, to provide a claimant with security. It is to restrain defendants from evading justice by dealing with or concealing assets otherwise than as they normally would. And by normally, I mean normally and lawfully. It is no part of the legitimate function of a Mareva to stop a corporate defendant from dealing with its assets in the normal course of its business. And that should permit not merely existing business commitments, but those which it might reasonably have wished to undertake had there been no injunction. Those in business who are unrestrained often take advantage of new opportunities and of development into other business areas and ventures. Should those subject to a Mareva be prevented from doing so, I ask? And similarly, for personal defendants, it's not the legitimate purpose of a Mareva to prevent them from conducting their personal affairs in the way they always have conducted them, providing, of course, that such conduct is legitimate. If they have done so through offshore vehicles, lawfully, for reasons of tax planning or family planning, that is not something which of itself necessarily demonstrates a risk of unjustified dissipation. However much they're continuing to do so will have the effect of hampering enforcement of a judgment. Take the example of a defendant who has always intended to spend their savings on a round-the-world tour when they retire. Are they, I ask, to be prevented from doing so because a claimant has what is only an arguable claim, and the effect would be to reduce the prospects of an enforceable judgment? Now, in the early jurisprudence, it was assumed that the Angel Bell proviso, permitting dealings in the ordinary course of business, was sufficient to address this aspect. But that proviso has been quite narrowly construed. It's been construed as meaning that it's for the defendant to come to the court to justify dealings if they're not existing business commitments, and it's been construed as wholly inapplicable to individuals rather than businesses. And with what I think is an increasing number of Marevas being granted against personal defendants, which used to be relatively rare, although not of course unknown, that may warrant some further attention. If it is thought to be desirable to rein in the number of Marevas being granted, should consideration be given, perhaps, to the risk of dissipation test being one of nefarious intent? Now, the conventional objection to that has been that such intent is very hard to prove. But in the cases where the claim itself is for fraudulent conduct, and that is directly relevant to risk of dissipation, which is not a given, but is often the case, and is a paradigm case in which Marevas are granted, that may not be very hard to establish. The test of risk of dissipation is whether there is a real risk, after all. It's not something which has to be proved on the balance of probabilities. And nefarious intent is something which is required in some jurisdictions, notably in Canada at federal level, and to some extent, although inconsistently, at province level. And in Canada, they also apply a balance of probabilities standard to the risk of dissipation. Nefarious intent is also required in the limited jurisdiction in New York under Section 62013 of the CPLR. In British Columbia, they've adopted a slightly different approach. They have what they avow to be a more flexible approach, in which, apart from the merits, there is simply a general balance of convenience assessment, to which risk of dissipation is inevitably a relevant and potentially important element, but not jurisdictionally necessary. Let me turn to the third topic, disclosure of assets. In Motorola Credit and Usen, Lord Justice Waller said, although it's an invasion of privacy to force any party to disclose assets, a freezing order in normal circumstances simply cannot be effective without that disclosure. It is, I think, the invariable practice now for a Mareva to include an order for disclosure of assets. I don't know whether anyone here has had experience within the last few decades, at least, of a Mareva being granted without disclosure, but I've certainly not come across it. In practice, the disclosure part of the order may operate as at least as onerous and perhaps more onerous as the freezing effect of the injunction itself. Typically, it will require disclosure of all assets worldwide above a relatively low threshold value for each individual asset. I've regularly seen orders with figures of £5,000 or £10,000 per asset in them. The standard order doesn't contemplate different limits for different classes of assets, real property, shares, chattels, jewellery, so on. It will require the disclosure in a very short time frame. It's perhaps telling that the standard order doesn't dictate the time frame, but requires filling in a blank for which the rubric is hours/days, and it's usually a short number of days. It requires disclosure of value, location, and detail of the assets without any guidance as to how much detail that involves, or whether value is gross or net of encumbrances. The defendant will usually be required to provide supporting documentation, if not in the original order, certainly once the claimant gets into correspondence, and often by way of a follow-up order. And that will have to be documentation, the exact nature and extent of which is left undefined by the order. So just consider for the moment, because I think people sometimes don't, the position from a defendant's point of view when they first receive the order, often by email. They face numerous practical challenges from a standing start and from a position of deep disadvantage. The claimant may have been preparing the application for months. The defendant suddenly gets the order. English may not be their native language. In the short time allowed, the first thing they need to do is find a lawyer who is willing and competent to act in what may be a complex piece of litigation. and who will first need to do know your client checks before the defendant can even receive any advice. And the defendant will want and need advice on what he can do and whether he can resist doing it. He'll inevitably want advice on whether he can challenge the order, whether on grounds that he has a good defence to the claim, or jurisdictional grounds, or once he's been told about the doctrine of full and frank disclosure, on grounds such as that. And that will often be a matter of considerable complexity and evidence heavy. They may need advice on the self-incrimination proviso by reference to incrimination not in the strict sense, but in relation to prejudice in foreign jurisdictions. They'll need advice on whether assets which are not in their own name are caught and require disclosure. And for all this, they must fund the lawyer in circumstances where the order will limit the sums allowed and may also require notification of the source of funds. And at the same time, the defendant may be having to deal with his banks or any other counterparties who the claimant has been able to locate and inform of the order, and who will be actively cutting off his financial support. And the amounts allowed for legal expenses in Marevas when they are first granted are often relatively small compared with the large amount of legal advice and work which will have to be undertaken, and sometimes, I have to say, quite unrealistically so. Now, claimants will say, well, if the defendant wants more money, they can come back to court and explain why. But that itself involves potentially an unfairness. It involves the claimant controlling the ability of a defendant to conduct the litigation as it wishes in its own interest. And it involves the claimant getting an insight into the privileged world, or what ought to be the privileged world, of what aspects of the litigation the defendant wants to be spending its money on. In practice, the defendant almost always has to give disclosure before there is any opportunity to challenge the order, so that the information and documentation is irrevocably in the hands of its opponent, even if it should turn out that it shouldn't be. The courts do not usually suspend the disclosure operation pending such a challenge. They won't, for example, order sealed disclosure by lodging the affidavits at court, but they're not being released to a claimant until after the resolution of a discharge application. And all this is undertaken in response to a court order bearing a penal notice where the defendant is at risk of criminal sanctions for contempt of court if there is any failure to comply in any respect with the order. And one must remember that to be in contempt, you do not have to do something which is a deliberate and intentional breach of the order. Contempt is committed by conduct which is deliberate, and which in fact breaches the order without any intention to breach the order. So advice on the exact meaning and application of the order is critical for a defendant. Moreover, experience tells us that in practice, disclosure is often weaponized by claimants to pursue relentless and extensive inquiries in correspondence involving alleged discrepancies or gaps or unexplained matters as part of an aggressive litigation strategy, sometimes then resulting in further applications to the court, often involving threats of contempt proceedings, and sometimes the actual commencement of contempt proceedings during the currency of the claim. I may be wrong, but I detect an increasing trend in that direction. And that can be a weapon of oppression, which is quite unrelated to the issues in the action, on which the defendant should be entitled to be spending their time and resources, quite apart from the unfortunate additional burden which that places on the court system when applications come before the court. And in all these various ways which I've been identifying, there can be a real inequality of arms which can operate unfairly. And there's a limit to the extent to which that can be ameliorated by careful consideration of the terms of the order in the first place. Yes, the time allowed for disclosure can be looked at carefully. Higher asset limits or more carefully delineated asset limits can be looked at more closely. More generous allowances for costs can be looked at. But of course, at that stage, there are countervailing considerations where the claimants will be able to put forward arguments which counterbalance the interests of the defendants. And none of that sort of close look at the order when it's first made can address the imbalance of the risk of contempt and the ability of the claimant to weaponize disclosure as a means of imposing litigation pressure on which is unrelated to the claim itself. And defendants are, I think, often justified in feeling like Paul Gascoigne in the hands of Vinnie Jones. So it may be worth, for a moment, re-examining the origins of disclosure orders being made and what the rationale for them is. The jurisdiction to order disclosure of assets was established in 1980, at first instance by Mr. Justice Robert Gough, as he then was, in A and C, and not long thereafter, in the same year, by the Court of Appeal in Beckor and Bilton. In A and C, the rationale identified by Mr. Justice Robert Gough was focused on amounts in bank accounts and the possibility that the sums in different bank accounts would all themselves be within the limit of the sum for which the Mareva had been granted, but which, if taken all together, would exceed the amount which ought to be frozen, but would remain frozen if everyone was in ignorance of the overall picture. Now, at first sight, that would seem to involve prejudice only to a defendant, which a defendant could cure by making voluntary disclosure and asking for the Mareva to be varied insofar as there were accounts which exceeded the sum, and going back to court if that couldn't be agreed. But it was said to justify an order for disclosure of assets to the plaintiff at the outset, because otherwise the plaintiff would have an excessive exposure on the cross-undertaking in damages. But there was no expression in that case of the justification lying in the plaintiff being able to police the order in the sense of checking up on whether it was being complied with. There was a hint of that in Beckor and Bilton, where the principle was expressed more widely by Lord Justice Ackner, that the court had power to make all such ancillary orders as appeared to the court to be just and convenient to ensure that the exercise of the jurisdiction is effective to achieve its purpose. He was part of the majority, which in fact refused to order disclosure on the facts of that case. Lord Justice Griffiths, who dissented on the facts in holding that disclosure should be ordered, did so by accepting the argument from counsel for the plaintiff, the larger-than-life Mr. Sam Stamler, QC, that disclosure was necessary to police the Mareva. And that is the shorthand which has stuck as the mantra for justifying disclosure. In fact, the argument in that case was that the policing was to enable the court to police its own orders. It was protection of the integrity of the court process rather than the protection of the rights of the plaintiff as such, although the two are obviously related. And Lord Justice Griffiths made a point of saying, and I quote, "The power to order discovery in support of a Mareva injunction should be sparingly exercised, and if too readily resorted to, could easily become a most oppressive procedure." A characteristically prescient observation from a man of many parts who won a military cross, opened the fast bowling for Glamorgan, and was president of the Royal and Ancient Golf Club, and had perhaps the bushiest eyebrows in the judiciary with a number of contenders. The policing metaphor has persisted. I thought you might enjoy a slide of what policing looked like in the 1970s, not very different from now. Those are the Lewisham riots in the bottom left. Other metaphors have been used. Lord Wolfe described an asset disclosure order as something which, quotes, gives the teeth which are critical to the freezing order. But like many metaphors, these can sometimes obscure rather than illuminate the rationale, which may be worth unpicking a little. There are, I think, typically two main aspects as to what the courts mean when they describe disclosure orders as necessary to police the injunction. The first is by enabling the assets to be secured by notification to third parties. As we know, one of the main ways in which Marevas are rendered effective is through reputable third parties, such as banks or solicitors, who would have to be aware of and assist in any dissipation in order for it to occur. Of course, that sort of notification is of limited assistance in relation to foreign individuals or institutions who are not amenable to the quasi-criminal contempt jurisdiction of the English courts. And it's in those cases, therefore, where it's necessary to seek relief from a foreign court, that it has been said that it is the disclosure which is the primary form of relief, and that the Mareva is ancillary to the disclosure rather than vice versa. That was what Mr. Lawrence Collins, as he then was, said in a 1989 LQR article, which Lord Justice Steyn, as he then was, described in 1994 as a seminal article. But the second aspect of what the courts mean by policing in this context, and I think predominantly what is meant, is that the disclosure is necessary to ensure compliance, or to put it more explicitly, to prevent a defendant from being able surreptitiously to disobey the injunction behind a curtain of ignorance drawn across the face of the claimant and of the court. And that policing rationale is and is usually expressed as being in terms of assuming nefarious intent. It's justified, it is said, to counter a defendant from seeking to dissipate assets in order to render themselves judgment-proof. As it was put in an Australian case, picking it up just below the beginning, an affidavit of discovery of assets may be ordered in every case where the information in such affidavit will further the court's purpose in defeating such a stratagem. The object must remain throughout to prevent disposal of assets in further of the illegitimate aim of making oneself judgment-proof and of stultifying the order of the court. Whatever needs to be done to achieve that objective, the court has power to order as part of its inherent jurisdiction. Now, if the disclosure is to protect against willful disobedience of the order, that is to say, a defendant who acts with nefarious intent, there is a disconnect between that rationale and the test for risk of dissipation, which doesn't require nefarious intent. And if this justification only arises if and because a defendant cannot be trusted to obey the order, is there a case, it must be asked, for treating nefarious intent cases differently for disclosure purposes from those where there is no evidence that the defendant will seek to deal with his assets in order to evade judgment, but the risk is merely that that may be the effect? Another question worth asking is whether policing should, in all cases, be exclusively in the hands of the claimant, or whether some form of disclosure to an independent third-party solicitor would work more fairly, at least in some cases. We're familiar with the use of supervising solicitors in the Anton Pillar jurisdiction. A solicitor, a third-party solicitor, would be able to notify third parties who control the assets so as to render dealing with them impossible. The third-party solicitor would be able to apply to the court for further disclosure if it appeared to be inadequate. The solicitor could inform the claimant if there were steps which the claimant, and only the claimant, might reasonably wish to and be able to take to secure assets abroad. But all that would be driven solely by considerations of making the Mareva effective. It would remove the ability of a claimant to use the order as a litigation weapon. No doubt, of course, that such an option would need a carefully thought through regimen to address the nature and scope of the information barrier between the solicitor and the claimant, and there might be many practical difficulties which would need to be worked out. But that there might be practical difficulties might not be something which should stand in the way of consideration as to whether it would be a good idea in principle. So, drawing to a close, there are many other areas which might also be thought to warrant consideration for reform: the scope of the assets which can be caught, aspects of the cross-undertaking in damages, both fortification and claims on the cross-undertaking come immediately to mind. I've only really scratched the surface, although I've been focusing on elements of the core. But can I just wrap up by saying something briefly about the practicalities of how reform might be considered if thought to be a topic which needs addressing. The areas that I've been addressing, merits test, risk of dissipation, disclosure, are really areas which have become pretty much entrenched. And the applicable principles and the boundaries for this ever-burgeoning forensic weapon have largely been fashioned on a piecemeal basis by individual decisions at first instance and by individual constitutions of the Court of Appeal. There's been precious little House of Lords, Supreme Court or Privy Council authority in reality, other than on jurisdictional aspects. And the develops haven't been coordinated by any collective process of discussion or informed by any comprehensive reassessment of the way in which Marevas have been working in practice. And that might be thought to give rise to a danger that the accretion of 50 years has given the Mareva an undesirable middle-aged spread, which, if there is an argument for reform, needs something more in the nature of a shot of Monjaro than trimming slowly on a meal-by-meal, case-by-case basis. And I wonder whether the time is now ripe for a comprehensive re-examination of the Mareva jurisdiction, involving widespread involvement and consultation amongst representatives from the judiciary, practitioners, academics, and those who are affected. I won't use the word stakeholders, which I hate, but that's probably what I mean. And it might be undertaken under the auspices of the Civil Procedure Rules Committee. It might be undertaken under the auspices of the Business and Property Courts, although, of course, Marevas extend beyond the Business and Property Court jurisdiction, and the experience in other jurisdictions, such as in family cases, might be of great value. And if that were thought to be a good idea, well, it might need to be a work of some considerable substance if it's going to carry authority in a way that could affect change to what are some of the entrenched elements of the jurisdiction. Now, it's not for me to say that a course like that is needed. I merely float the idea in a Rachel Reeves sort of way. Thank you for listening, if you have been.
Thank you. It just falls to me on behalf of us all to thank you for the most careful, thoughtful and entertaining, particularly love the slides, lecture. I rather suspect that views in this room will depend on whether your experience of the Mareva injunction is on the Vinnie Jones claimant side or the Paul Gascoigne defendant side, but I have no doubt that you've given us all much food for thought. I also have no doubt that your careful analysis was a very fitting one for this year's lecture, marking 50 years of Jonathan's practice. Thank you very much. Thank you.